Hi everyone, this video is for HCA 322 Healthcare Ethics and Medical Law at Ashford University, and it's for my Week 2 Discussion 2. My name is Haley Tigner, and I am serving as a juror on the Molina versus Ashford Hospital case, where the plaintiff, Megan Molina, claims that as both an employee and a patient at Ashford Hospital, her privacy was compromised by the hospital because her personal information was released to her supervisor due to her receiving surgery at Ashford Hospital. So she was in the care of the hospital that she also was employed for. Some of the personal information that was shared was included her social security number, her birth date, her age, her residence, her insurance for billing and payment information, former and current surgeries and medications, past medical conditions that she had, and various healthcare professionals that she's seen within the past year. The plaintiff believes that the release of this information to her supervisor violated her rights as stated under the privacy rule that is within HIPAA. On the other side, the defendant, Fiona Grant, who is representing Ashford Hospital, claims that the hospital is not violating any of the plaintiff's rights within the case, because the plaintiff's supervisor is a senior administrator at Ashford Hospital, and being in that position, he receives all the patient records as part of his job description anyways. So in this case, I chose to side with the defendant and Ashford Hospital. Because the patient is also an employee at the hospital, I don't believe that that means that her medical information is exempt from being shared with the hospital, and any of the proper administrators that would be allowed to see her medical records. I think she should be treated just as any other patient would be, even that the ones that don't have personal ties with the hospital through employment. According to the defendant, the senior administrator is included in emails regarding patient care, and it's necessary in carrying out further information processing, anything that has to do with the patient and their care anyways. I think as the administrator, this gives him the right to the information in the patient's records. According to HIPAA, any healthcare provider entity that assists in processing patient information in order to carry out things like billing information or any further services has rights to access these records. So basically this includes the administrator as part of a third party or business associate in care of the patient records when it comes to their information and processing it, and their care. According to the U.S. Department of Health and Human Services, when a patient signs a consent form, they are agreeing that they understand the procedure in its totality, and this includes the sharing of information related to their treatment in order to further their medical care and the confidentiality that relates to that. The administrator is simply just a piece of the puzzle that is needed in order to provide the plaintiff with the care of her medical treatment in its entirety. One of the things that the plaintiff brought up that could have possibly been a solution was classifying her as a Jane Doe. But I think that this would entail tampering of the records, and it could cause confusion and potentially interrupt the correctness of the patient's records. So I think it's best to leave it as it is. Another good point that the defendant made was that through the California law, it's allowed of the agency to determine who gets to see which records and to what extent those records are shared. So Ashford Hospital allows a senior administrator access to these medical records because they're legally given the right to determine that he does. If the plaintiff was concerned about the proper people having access to her medical records and fear of judgment by her employer because of her medical history and the personal information that's placed on there, she simply could have just reached out to a different facility to receive her care from. So overall, I don't see that any of the privacy rule components were violated in this case. The patient consented her care to the hospital, so she should know as an employee of that hospital what all that entails and who gets to see it, and agreeing that the appropriate parties would have access to her records, and that's including her supervisor. And this is for her well-being and in order for all of her records to have the proper information placed on it and for it to be passed along to the next step in order to further her care. So thank you, and we'll see how it goes.